I will let you know whenever we are good.
Perfect.
Setting up. It's taking a couple minutes, but it's almost done.
Great.
All right. We're live.
Good afternoon, everybody, and thank you for coming to our AMOS presentation on pro se parties. I'm Lisa Nelson. I'm a staff attorney with Texas Legal Service Center. Before I get started on my presentation, I'm going to give you a quick look at our website so that you know what to look for. This is our website. It's texaslawhelp.org. Mine looks a little bit different because I have access to the back end to make changes to it. It has a comprehensive amount of all topics on all civil legal areas. And from 10 to 2, Monday through Thursday, we have live chat available with licensed attorneys. You will see the icon right here when chat is available. If you come to our website during those times and you don't see the live chat button, just wait a few minutes. That means that all of the attorneys are busy, but they will turn chat on again as soon as they're available. I'm here to talk to you about pro se representation. We're going to do a little introduction and talk about what courts can and can't do, and then go through the 3 stages of the trial. If we have time, I'm going to do a quick demonstration of our website. Our Texas Law Help is designed to help all Texans navigate civil legal areas. We even have detailed forms and instructions so that you could represent yourself in court. And I'll be sure to leave time for questions. And the only thing I ask is that this is not meant to be legal advice. This is legal information only. I am not here to represent your case. If you have questions, please keep them as general as possible, because you don't want your private business being broadcast on the internet. We are live on YouTube and Facebook, and I don't want you to share your information with the general public. Texas Legal Service Center was founded in 1981. We're a statewide nonprofit organization that provides legal advice, advocacy, representation, and education to underserved people across the state. We have more than a dozen practice areas, and we touch almost every aspect of civil law that affects Texans. I am not going to go into detail with the slide. I have it up here because I just want you to understand how many programs we have. We have several programs to help with all types of parenting and family law issues. We have a website for people over 60. We have employment. We have a lot of programs for overcoming violence, abuse, and stalking. So, please check our website, tlsc.org, and you can see all of the programs in detail that we offer. I'm an attorney with Texas Law Help, and our mission is to empower self-represented litigants. We offer advice, court-approved legal forms, and instructions so that you can achieve the best outcome in your case. I'm going to start off with some basic vocabulary and information about the courts. If you do not have an attorney and you're involved in a court case, you are proceeding pro se. So if you were in court and you're representing yourself, you are called a pro se litigant or a self-represented litigant. In family law, you can absolutely represent yourself in any divorce, custody cases, anything like that. If you own your own business you can only represent yourself if you have a DBA. So if you're a small business, you just are doing business as Bob's Plumbing, then you can represent yourself in court. But if you have a corporation or another business entity, you will need to have an attorney. Because if you have a corporation, that is considered a separate legal entity. And a person who is not an attorney can absolutely represent themselves. They cannot represent other people, and that would include representing a legal entity. For probate and guardianship cases, you need an attorney because, again, you're representing more than yourself. You're representing the estate of someone. So pro se is a person who represents themselves in a court case. The petitioner or plaintiff is the person who files the petition that initiates any case. Respondent or defendant is the person who is responding to that lawsuit. They're being served by the petitioner. The petition is the initial document filed with the court to initiate the lawsuit. Service is the process of giving someone formal notice that they have been sued. And an answer is a legal form filed with the court to respond to the petition. If you have been served, always file an answer. You do not want to have a default judgment filed against you. Uncontested case means that both sides agree on the desired outcome and are using the court system to make their agreement legally binding. This is most common in divorces, where both parties have decided they no longer wish to be married, and they agree on all the aspects of the divorce. Contested cases are when the two parties don't agree on the outcome. A default judgment is when somebody does not file an answer or appear at a hearing. That's why I said a few minutes ago to always file an answer. If you were served with a lawsuit and you ignore it, the other party can get a default judgment against you. You will not have had any involvement in that in the court process. A motion is a written document that you ask that you're asking the judge to give you to order things before or during trial. And trial is a process where a court or jury listens to you and makes a decision about your case. There's a lot of confusion about what court staff can and can't do because I help pro se parties all the time. They get really frustrated because they'll call the court to ask for a question, and quite often the court will say, I cannot give you legal advice. Here's what the court staff can do. They can and they will review your papers to make sure they're complete. They make sure that everything is signed, that anything that needs to be notarized is notarized. They'll make sure that you're filing in the correct county and that you've used the correct case number and that all of your attachments are there. Court staff can also give you general information about court rules, procedures, and practices. They can provide court schedules and information on how to schedule a case. And they can give you information from your case file, such as where and when your next hearing is. These are things court staff cannot do. They absolutely cannot provide legal advice, interpretations, or recommendations about what to do. They absolutely cannot predict what will happen if you decide to bring a case to court. They cannot look through your court papers and tell you what to say. They absolutely cannot talk to the judge for you, and court staff cannot provide any confidential information about cases, other parties, or court operations. So the first stage in a case is pretrial, and it's actually a whole lot of work. The most important thing you need to do is research your claim. This helps you learn whether you have a good case. After I finish the slides, I'll show you the information we have, but we have research guides at Texas Law Help that will help you learn about the law and how to do legal research. I recommend that everybody get familiar with this site, even if you're able to hire an attorney or you're able to get legal aid to represent you. It's really good for you to educate yourself so you understand what is going on. One of the most important things you can do when trying to decide whether to bring a case is to develop a detailed timeline. You want to list the dates and times of everything that is critical in your case. You also want to, as you're getting started, before you filed your case, you want to look for the guides and forms you need on Texas Law Help. We provide you with detailed instructions and guides. Here's an example on our self-help support of all the different articles we have on how to do legal research. We try to have as much as possible on our website, but Texas has fabulous law libraries, and we always want to recommend that you can use those for more research. Texas Legal Service Center has virtual court kiosks. They are a small booth that are in different parts across Texas that has a computer, a printer, a scanner, and a camera. You can use our computer to do legal research. You can use it to file your court documents, to print and file and get your court documents together. You can also use our kiosk to attend any virtual courts. A lot of courts still have Zoom court, and you can print and scan for free. You want to go to our website and look for the kiosks, and we have a map so that you can find where they're located in Texas. They are accessible in Spanish and English, and you do need to schedule an appointment ahead of time so that you know the kiosk will be reserved for you. Even before you file your initial petition, think about whether you can settle the case. It's pretty unusual to go to trial. If you settle your case, it saves you time, money, and it might even prevent conflicts and personal relationships, excuse me. So if it is safe to do so, talk with the other side to talk about how to resolve your case. Our forms are designed for uncontested cases. If you file an uncontested case, it's a lot easier to get through the system and have your goals accomplished. There's also a resource in most counties that's a domestic relations office. You should look for your county name, DRO, to search for it online, and they offer services to help you resolve your case. Okay, so a DRO is the Domestic Relations Office in most large counties in Texas. They exist to strengthen families and provide services to parties, parents, and children in family district courts. They offer numerous services, including affordable mediation, assistance with child support, custody and visitation disputes, and support for pro se parties. Once you have done your research and are familiar with the law, you want to file your case. So after you complete the petition, you can either file it electronically, which is on the web, or you can file it in person at the courthouse. One thing that's important to know, if you cannot afford an attorney, you should also file a statement of inability to afford costs. If you can't afford filing fees, that does not mean that you don't deserve justice. You can file that form and it will cover your filing fees and other court fees. So if you decide to file in person at the courthouse, take 3 copies of your petition along with the filing fee and the statement of inability to pay, if that applies to you. If you file online, there is a state e-file provider called eFile Texas. They have a self-help guide for filing, and they also have a guided interview process that will walk you through the steps to put together common forms. Don't worry about selecting your court number or case number. That is something the clerk assigns once you file your case. Okay, after you file your petition with the court and it has been accepted with the court. So for example, if you file it electronically, you will get an email within a few minutes of filing it, and you will get a second email after the clerk accepts your case. That email can be anything from a few hours to a day or so. I know in Fort Bend County, sometimes it takes a few days. It just depends on clerk staffing. You must give the other side notice. You can't go through a court process and the judge will not give you what you want if you don't prove that you have given notice to the other side. So when you file the petition, you ask the clerk to issue citation, and you can ask them to serve the other side. You have 2 options here. You can hire a private process server, or you can ask the clerk to serve the other party. You can ask the clerk to serve the other party either by certified mail or by constable. It's really best if you can use a process server or a constable. Certified mail can be very slow, and a lot of times people refuse anytime there's a certified mail because they assume it's trouble. After you serve them with notice of the suit, they have a deadline to file an answer. It's really important to file an answer because it shows that you want to take part in the case and you're not ignoring the court's authority. There is no filing fee for an answer. If the respondent has their own claim against the petitioner, they can file a counterposition. For example, one side files for divorce and the other side says, wait a minute, I want to get divorced, but none of this is true. They can file a counter petition stating what they disagree about in the original petition. And again, the other side also is entitled to file a statement of inability to pay costs. After the other side has been served and hopefully files an answer, we have what's called the discovery phase. If it is a contested case, you and the other party need to engage in discovery, which is the process of gathering and exchanging evidence for a court case. There is some information that both of you are required to disclose to the other side. You have to exchange evidence that you plan to use, and there are certain legal disclosures that are required in every case. If you do not present that to the other side before going to trial, the judge probably will not let you introduce that evidence at trial. There are very strict limits and deadlines for discovery. If you have a more complex case, the court will issue what is called a DCO, which is a docket control order. That will include every deadline for the case, including discovery. And if you are served with discovery requests, you absolutely have to respond to them on time. Usually you have 30 days to respond to a discovery request. If you don't list the witnesses and the evidence that you need, the judge may not allow you to use that evidence, because it's not fair to have a lawsuit where you don't know what is being accused, what the accusations are, and what evidence is going to be used against you. Next, we go to trial. During trial, you go in front of a judge or jury to present your facts and evidence to persuade the judge or jury that you are in the right and that you should be awarded your relief. Trial is really complicated, so it's important for you to spend at least a few weeks preparing for trial. You don't want to have any surprises in the courtroom. Once you get to trial, you don't have the chance to do research. Everything is happening right then and there. So you want to prepare for all possible outcomes in advance, so you're ready to participate even if things go differently than you expected. There's an important checklist that you need to go through in order to prepare for trial. You need to check to see if your court has local rules. Texas courts can make their own rules. Most counties have county-wide local rules, and sometimes every court in a county has the same rules. What you want to do is check with the court's website, check with the court clerk, and see if that particular judge has local rules. Local rules don't change the rules of evidence. They don't change basic trial rules, but they cover things such as scheduling, deadlines for filing legal documents, and appropriate attire and other legal procedures. If you're not dressed appropriately, the judge may not let you come into the court. Now, don't worry. You don't need to have a formal suit and jacket. You should dress as you would for any important event. You know, dress pants, slacks, khakis, and jeans. If they're very nice jeans without holes or tears are just fine. Dresses and skirts are fine if they're not short. And absolutely do not wear shorts. It's best to wear button-down, long-sleeve shirts. A tie isn't necessary. That's up to your comfort level. And it's important that you don't wear anything like spaghetti straps, crop tops, halter tops, tube tops, and open shoulder tops. That is not appropriate, and the judge may not let you go into the courtroom. Here's a couple of other things to consider with your attire. A lot of courts will want you to cover any visible tattoos or piercings. You absolutely cannot wear a hat or sunglasses. The only head coverings admitted in court are if you need a head covering for religious or medical reasons. It's important to wear comfortable shoes. I know we all want to look our best, but even if you have a parking spot very close to the courthouse, you still may need to do a lot of walking to get into the courtroom. Some courts will not let you come in with open-toed shoes, and you need to be prepared to go through security. In my experience, Harris County has more strict security than any airport. You have to take off your shoes, your jacket, your belt, your watch, and they go through everything. So be prepared to slip off your shoes. Don't wear boots or something that's more complicated to take off. And then before you appear in court, you want to spend time getting all your documents and evidence together. Evidence include testimony, and that's just a witness giving testimony under oath about the facts of the case. That is your witness stating the facts of the case. Documentary evidence refers to writings on paper and applies to other ways to preserve information. So that could be an audio or video recording, a 911 call transcript, or a video through a cell phone. Documentary evidence includes police reports, diaries, letters, photographs, contracts, recordings, and printouts of digital evidence such as email, text messages, and posts on social media. Tangible evidence is evidence that somebody can hold. For example, you print out transcripts of conversations that you had, and the judge and jury can actually hold on to those. There's also demonstrative evidence, and that's used to explain witness testimony. That would be charts, maps, and diagrams. The most common example of this is if it's a car accident case and you have a diagram to show where the cars hit in the intersection. You can also develop a timeline and have that on a big poster board showing all the steps that led to the lawsuit. If you have witnesses, that's terrific. You need to let them know that they also have to follow the same rules of court. They have to let them know about the dress code, that they need to be there when the docket is called, and that they have to be there in person. Now, if you have a witness that is outside your county, you can ask the court for permission to have them appear by Zoom. Please do that at least 2 weeks, if not earlier, before your case goes to trial or a hearing, because it takes some time for that to go through the process. There is something in Texas law that's called the rule. What the rule is it prevents all witnesses, except for a spouse, from hearing the testimony of other witnesses. Your witness also should be prepared all day at the courthouse. If the other side invokes the rule, all the witnesses will be put in another room and they'll have to wait till it's their turn to speak. You cannot bring a child to court without the judge's permission. Judges don't like people to bring their children to court. If it's very important for your child to testify, you need to file a motion with the court requesting the judge's permission to talk with the child. You cannot assume that the judge is automatically going to let your child speak. You cannot use written statements from your witnesses. They have to be present to testify because it's the other side's constitutional right to be able to question them. You want to prepare ahead of time with the written questions. In my opinion, and I've been doing this a long time, I have a detailed outline before I go to court. It's easy to get nervous and you don't want to forget anything. So what I recommend doing is prepare the written question, prepare a list of questions that you're going to ask your witness. The first thing you need to ask is to state their full name, date of birth, age, address, where they work, and how they have personal knowledge of any facts. I think it's a great idea to maybe the day before you go to court, go over the questions and practice with your witnesses so everybody's ready. If you are using documents, for example, copies of text messages, you need to have an original copy for the judge as well as 3 other copies. For anything you're bringing in that you plan to show the judge and jury as evidence, you need one for the judge, one for the other side, one for the lawyer, if the other side has a lawyer, and one for the court reporter. Evidence is the way that you can prove or disprove the facts in your case. You can, the rules of evidence can be confusing, and you need to understand that you're going to be held to the same standard as a licensed attorney if you represent yourself in court. Be sure to study the rules of evidence and be ready in advance. Like I said, I think it's really great to have an outline, write down your timeline, and write down everything you want to say to the judge or the jury, and practice it. Practice it by yourself. Practice it with a friend or family member. It really helps if you go over things a few times so that you're more comfortable presenting your case and you remember everything. With most cases, there are required documents and proposed orders that you have to file. So you need to read everything filed by the other side. And if you don't understand anything, if you don't understand something, talk to an attorney. If you need to file legal documents, make sure you do it at least 7 days before your hearing and trial, and you must provide a copy to the other party. You must always be sure that you serve the other party. If you do not serve the other party with something you want to present to the judge or the jury, you will not be allowed to present it in court. In most cases, whenever you file something, you also have to file a proposed order. The judge doesn't want you to just file, here's my petition, this is what I want, or here's my motion to exclude evidence from the other side. You need to give them an order to sign so that they have that ready to do. The judges do not prepare their own orders. If you do not speak English and you need an interpreter, you cannot use a family member. You need to request a licensed court interpreter at least 1 week before your court appearance. The sooner you do it, the better. They have to provide this to you for free if you cannot afford it. Another great tip for getting ready for court is if you've got time, visit the courtroom where your hearing's going to occur. Not on the day of, a few days before, a week before. Call the court coordinator to get the judge's schedule, and you can find out when the judge hears cases similar to yours, and you can just sit in the back of the courtroom and watch what happens, and you'll feel much more comfortable about what to expect. After the trial, even if the judge has granted everything, you're not necessarily done. Deadlines are absolutely critical in this situation. Pay attention to what the rules are. Whether you agree or disagree, you need to pay attention to those deadlines. They tell you how long you must wait before your judgment is no longer eligible for appeal. Appellate cases are very complicated and often overwhelming. It's a highly specialized area of the law, and it's really best to have an attorney if you want to appeal your case. If you don't agree with the outcome of your case, you have several options. You can file a motion to set aside a judgment. You can file an appeal. Other things that can happen after the trial include modifications and enforcements. For example, a modification would be you have a child support case. The other party is paying child support, but you know that they're making more money than what they disclosed to the judge. You can file a modification and have the court reopen that case and look into what they should be paying. Enforcement is a critical action as well. It can be enforcement of paying child support and enforcement of settling a judgment. They lost, I won. I need to enforce this action so that they actually give me what the court ordered them to give me. In Harris County, we have a wealth of resources for people representing themselves. Our website, Texas Law Help, is of course statewide. These are our AMOS partners. Earl Carl Property Preservation helps with some legal issues related to property. Lone Star Legal Aid is one of the state's biggest legal providers and helps with pretty much every area of civil law. Houston Volunteer Lawyers also has a wide bench of lawyers that will help you with your case for free. Every state bar association has a legal line, and it is an incredible resource. You get a 20 to 30-minute consult with an attorney for free. They are not legally allowed to take your case, but they can explain your issue to you, and they can help you with your next steps. Houston Lawyer Referral Service also is a great service. They can provide you with the names of attorneys in the area where you need help. You can ask for people that charge low fees. The other great bargain about referral services is you get a 30-minute consultation with a lawyer for $20. Sometimes that's all you need to figure out how to go forward. Harris County Law Library is fantastic. They have an incredible amount of resources, and they're very helpful to pro se parties. You are also entitled to use law school libraries. Legal libraries must be open to the public because we all have the right to represent yourself. That is the end of my presentation. I'm going to give you a minute for questions if you have them. And otherwise, I can show you my website, our website. Okay, there's not any questions, so I'm going to give you a quick tour of our website. Just one second. Since it's not yet 2, we still have live chat available. You could click that. There's a brief screening questionnaire, and then you will be able to talk to an attorney. Every Texan is welcome to get legal information. We are glad to provide legal information to everyone. If you are 125% or lower of the federal poverty limit, you are eligible for free legal advice. So again, I showed you the topics earlier. They cover pretty much every area. I will go through divorce in a second because that's the most common. We also have self-help guides. And these are the kits that show you all the different issues you can have. So you can select a topic and find out. For example, let's look at house and apartment. I need information about evictions. Okay, it gives you examples about how to pass on your house without probate and how to deal with an eviction. Or you can go to money and debt. And we even have subcategories. So I'm having a problem with a debt collector. And again, they've got how to answer a debt collection case and how to appeal the case. So as you can see, it covers quite a lot. We also have information on legal assistance. We have a detailed legal directory for every single county in Texas. You can select to find the attorneys there and then for all the different areas of expertise. There are also legal events and clinics, which you can look up here. And our website, I'm very proud to say, is available in English, Spanish, and Vietnamese. So say you're going to get divorced and you don't know where to start, but what you would do is you would click divorce. And you would get 1,940 results. We've got forms for filing a divorce without children. I'll go through that because it's easy. So this is an article that explains all the processes for going through divorce when you do not have children under 18, including resources if you're afraid of your spouse. This is really critical. We have a lot of stuff that is written for family law cases, but in some ways it applies to every cases. So I recommend, find the information on your specific case area, but then take a look at the family law cases too, because they have articles on how to represent yourself, how to afford an attorney in a family law case, but you can use it for any circumstance. And this is in detail doing all of our information about divorces. And if you scroll down to the bottom, I want to show you the guides. Okay, we have guides for most topics. We have it for not having children and having children. The guide starts with an overview, which covers the common questions. Every guide has instructions and forms. So you want to read through this overview because it will answer a lot of the questions that might come up while you're preparing your forms. Then you go to the instructions and forms tab, and we have two types of forms. We have forms for agreed cases, which is also non-contested, and the other one is for default cases. An agreed divorce, both parties have entered an appearance. The other spouse has either signed a waiver or filed an answer, and they agree on everything. We've got a full set of forms for that. There are also default cases. What a default case is if the other side does not respond. So if someone files for divorce, they get their spouse served, but they can't find their spouse anywhere, they can then go on and do a default divorce. So this is important to know if you're ever sued. If you do not file an answer, the other side can get a default decision, which means they basically get everything they want. So let me go through the agreed divorce. This includes all of our articles, and then we have a detailed checklist. So it talks about how to know where to file your divorce. Then here's the starting forms you need. The original petition is your original starting form, and it includes all the other all the other forms that you need to fill out. Then we have instructions on how to file either at the clerk's office at the courthouse or online. And as you can see, we go through all the steps. Here's what the other side needs to do in a divorce. And then when you're ready to go to court, here are the final decree forms. Again, with any lawsuit that you have, you want to go through every single step and read every article that we have because you don't want to miss any steps. And it goes with the closing. If you can have an attorney review your form, that's great. If your spouse will sign the form, that's really terrific. In Texas, you have to wait 60 days in most circumstances. There are some circumstances and abusive situations where you do not have to wait the 60 days. And it goes through everything you need to do to finish your divorce. Now that is all I have today. I don't know if anyone has any questions. Otherwise, we'll let everybody go early. But I'm glad to answer any questions that you have. MSC, thank you so much for your compliments. I'm so glad that you learned.
Thank you so much, Lisa. I check all the social media and I don't see any comment or question.
Okay. Well, let's maybe give 5 minutes if anybody has anything, and then we can let it go, and hopefully we'll get more people next time.
Yes.
And to both of you here in the presentation, please feel free, check out our website, see everything that, here, I'll put it in the comment in the chat as well. Even as an attorney, I have used this before I came to work here. I use this website all of the time because it's a great starting place to do your research when it's a new area of law.
Mm-hmm. I see that they have in different languages, the website.
Yeah.
That.
Yeah, we're really proud about that. And we use professional translators to do that. Mm. And not every day, but most days we have attorneys who speak Spanish.
Awesome. That's great. That's so helpful. I think you sent it to me, but I will.
I sure did. I'm sorry, everybody. Let me send it again.
Oh, okay. Mm-hmm. Now you send it to everyone.
There we go. And I'll give her. Well, I think we're good to go.
Mm-hmm. Okay.
I don't know if there's anything you need to say. Thank you both for
Um,
coming. I really appreciate it. And I'm
you're
glad that you
welcome.
enjoyed the presentation.
I'm just gonna send in the chat our website in case they want to join us for our next workshop that we have this month. It's www.nrcdc.org. And you can go to the events and you can see all the workshops that we have this month.
We have a lot of great topics coming up.
Mm-hmm. We have. All right. Well, thank you so much, Lisa.
Thank you so much, Diane. I really appreciate your help, and I'll see you soon.
See you soon. Bye-bye.
Bye-bye.